Hi everyone, my name is Angie Thomas. I am here at the pro-life headquarters of Louisiana at Louisiana Right to Life, and I am giving a talk today on how did abortion become legal. We hope to explore some of the legal cases that brought us to this point, and also I'd like to share some of the things that were going on in society at that time. So let's dive right in. Okay, so first I would like to kind of mention that abortion, the concept of abortion, has really been around for as long as humanity has. So the first recorded evidence of abortions was back in the year 1550 BCE, found in Egyptian records. So this is not a new thing. Right? So what the new thing, or relatively new thing, is the legalization of abortion. So there's also records in Chinese records in 1550 to 500 BCE. So that's been around for a very long time. So has murder, so has kidnapping, so has rape. Right? All of these laws that protect us from difficult things, from horrible things, have been around. And that's where the United States was with abortion for many, many years. It protected the unborn from the difficulty, the horror of abortion. But around the 60s, 1960s, we start to see a bit of a shift in society. So let's really put ourselves back into that time frame and think about what was going on that set the stage for the legalization of abortion. Late 60s, I'm thinking Woodstock, I'm thinking hippies, I'm thinking free love. That's what was going on in that time. And so there was a real movement, a sexual revolution that was happening. And people were essentially trying to remove the consequences of sex from the act of sex. So we really are seeing this setting of a stage for being able to live a certain lifestyle. So let's make this personal. Let's really look at some of the players here in the mid to late 60s. So first of all, I want to talk about a man named Dr. Bernard Nathanson. Dr. Bernard Nathanson was an OBGYN resident in New York in the mid to late 60s. And in his book called Aborting America, he shares just a remarkable amount of information about his experience at that time. He did find that poor women were coming into the ER with self-induced abortions, coat hanger abortions, and that I do believe was what fueled his passion for abortion at that time. It was coming from a seemingly compassionate place, right? That these poor women were in a difficult place. We're not denying that. So Dr. Nathanson is really getting fueled with passion for this. And he meets a man named Larry Lader. Larry Lader is a sociologist, and his topic was population control. He thought abortion was a great way to handle this problem. So Larry Lader and Dr. Nathanson got together, and they formed a group called NARAL, which is still around today, the National Abortion Rights Action League. And Dr. Nathanson and Larry Lader would strategize about how they could get abortion to be legal in America. And not just legal, but it was important to them that it was unrestricted. And so these two men, over cocktails on vacation, would sit down and talk about how they could do this. And I just remember reading in that book that one of the first things that they knew they had to do was they had to convince women that abortion was good for them. Now, the first wave of feminism back when women were fighting for the right to vote. People like Alice Paul. I'll never forget this quote from Alice Paul. Abortion is the ultimate exploitation of women. That's what those early feminists thought about abortion. Now, something different happened. Dr. Nathanson and Larry Lader approached the president of NOW, the National Organization of Women. Her name is Betty Friedan, and she talked with them about this topic. Obviously, it was a little more complicated than one conversation, but Betty Friedan was told about the numbers of women dying from coat hanger abortions. Dr. Nathanson, in his book, did talk about the fact that he lied about a lot of those numbers. So that is evidenced in the book, Aborting America, that Dr. Nathanson wrote. But nonetheless, Betty Friedan bought this concept of abortion, that it was good for women. They told her, how will women ever be equal in the workforce if they don't have control over their bodies? So, and we know that that's not true, that women bring a very unique perspective to the workplace, and abortion does not have to be a part of that. But that's a whole topic for a different conversation. So Betty Friedan really essentially made abortion the hallmark issue of the feminist movement. And that all happened with those big players in those early days. So that book, Aborting America, was extremely eye-opening for me. And Dr. Nathanson in that book talks about how he did change his mind with a certain technology that came out in the mid-70s. Dr. Nathanson opened up an abortion clinic in New York after it was legalized in New York. Dr. Nathanson presided over many, many abortions, including his own child. I believe it was about 75,000 abortions that Dr. Nathanson claims to have presided over. But in the mid-70s, there was a certain technology that came out that caused Dr. Nathanson to really question where he was with this. And I'm sure you're thinking of it right now if you're watching this. Ultrasound technology. Before this, abortion was a blind procedure. So you really couldn't see what was happening. They would use these machines, the suction aspiration machines, to empty the contents of the uterus. And if you remember, you still hear this every now and then, but for the most part, I don't think people can deny that there is a unique human being in there. But you still hear every now and then a blob of tissue. Well, that was truly the narrative back then, the blob of tissue that would come out through that blind procedure. Now, again, with not just regular ultrasound technology, but now we're into 3D, 4D technology, we really can see what's in the womb. We can even give unborn children surgeries while they're in the womb. So we know the reality now. But back then they didn't. And so when Dr. Nathanson saw the reality of what he was doing, he decided, based purely on science, that it was wrong and that he couldn't participate in it anymore. Now, later on in his life, he did write a second book called The Hand of God, where Dr. Nathanson went further in his conversion and truly accepted the mercy that was waiting there for him. And so it was just beautiful to read this second book called The Hand of God. I highly recommend that book. So that's kind of what was going on socially. And so that's setting the stage legally. So let's dive into some of these cases that brought us to the point of today, where abortion is unfortunately legal in all of the United States. Now, some states have done a great job of passing incremental legislation to at least make women safer and at least help women to really think about what they're doing before they go into this. But we're going to go through a lot of these cases and see kind of the ebb and flow of what's happened with Supreme Court cases. So let's start our legal history with the Griswold versus Connecticut case. And this case was back in 1965, and this case was about contraceptives. And so what's unique about this case and why I start with this case is that this case was the first case to talk about the right to privacy. A lot of people mistakenly think that that language is found in the Constitution. It is not. It was in this case in 1965. And this case was about the right of married couples to use contraceptives. Many states had on the books laws about contraceptives being illegal. So this case, along with a case called Eisenstadt versus Baird, which was about single people using contraceptives. Both of these cases kind of came together with that right to privacy language. And I'm going to read this quote, and I think you're going to see why I start with this case and why it leads us directly into the abortion cases. Okay? So this is from the opinion in Griswold versus Connecticut. If the right to privacy means anything, it is the right of the individual, married or single, to be free from unwarranted government intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. So, regardless of whether you agree with that or not, what I'm trying to show is the language that was planted in that case very easily is then translated into the Roe versus Wade just 8 years down the road. So, in 1973, the case of Roe versus Wade came before the U.S. Supreme Court. Now, I want to make a point here. We talked about Dr. Nathanson providing abortions in the early days. Roe versus Wade was the decision that made abortion a right in all of the country. But abortion was legal in some states prior to Roe versus Wade. Hawaii, New York, I believe then California, Oregon. I think it was about 6 states that had already legalized abortion before the Roe versus Wade decision. And so by 1973, Dr. Nathanson's abortion clinic was thriving, even before Roe versus Wade. So Roe versus Wade creates a right to abortion and does it through the right to privacy. It creates a trimester framework, and honestly, legal commentators on both sides of this issue, this is such a controversial issue, but if you really can just read it with eyes open, it's a very poorly reasoned case. It's essentially, it talks about the state's interest in potential life, right? It says we're not going to talk about when life begins. But we do have at least an interest in potential life. And talks about that, but then turns around and says, so abortion's legal. And that those interests, weighing those interests of the interest in potential life and the interest in the woman's right to an abortion, that trimester framework is weighed so to where the woman's right is bigger in the first trimester, so there can be less restrictions, and that in the third trimester the state's interest in that life is bigger, and so you can have more restrictions. So a side note, Roe versus Wade, her name is Norma McCorvey, and she, just like Dr. Nathanson, had a true conversion of heart on this issue and really lived her last years trying to overturn Roe versus Wade. So that's we're kind of seeing a pattern here, because in the companion case of Roe versus Wade, Doe versus Bolton, That woman's name was Sandra Cano. And Sandra Cano also had a conversion and also became pro-life and really tried to fight against this. And so of all of these players we've talked about, many of them, once they saw the reality of abortion, once they saw it, beyond the legal issue, beyond a political issue, when they saw the reality of what was happening, they had that change of heart. So I think that's one takeaway that I'd love for you to get from this talk, is that, regardless of where you stand when you hit the play button, is that we need to look at this beyond the political realm, beyond the legal realm. It's a human issue, and we all recognize on both sides, I think, that it's a difficult place to be. It's a difficult situation, and as pro-lifers, we're not suggesting that the woman just has to deal with it, right? We are saying we have to help her. We have to empower her to be in a good place with this, right? Help her financially and emotionally, and that's ultimately the main reasons for abortion. That's in the Alan Guttmacher Institute, which is the research arm of Planned Parenthood. They're the ones that stated that those are the main reasons for abortions: lack of financial resources and lack of emotional support. So as pro-lifers, we really need to do more to help with financial resources and emotional support for women. So back to our legal history. So Doe versus Bolton came down at the same time as Roe versus Wade as a companion case. So Roe versus Wade says women have the right to an abortion if their life or health is in danger. Okay, life, that's pretty easy to understand if the life is in danger. But what about health? Where are we drawing the line here? That's where Doe versus Bolton comes in. Doe versus Bolton was really the heavy hitter here because of its broad definition of health. Doe defines health as the medical judgment that may be exercised in light of all factors: physical, emotional, psychological, familial, and the woman's age, relevant to the well-being of the patient. So all of those factors, they're saying, relate to health. So fast forward many, many years, I'll never forget reading about one of the abortionists that was doing late-term abortions. And for some reason, his records were revealed, or parts of the charts were revealed. And in those records, it time after time for 30-plus week abortions, the charts would say emotional distress, emotional distress, emotional distress. So what we can see here is that the doctor is making this judgment call. The doctor is also getting paid to do this. And so what reason has he to do, to really look into this? So that you just see kind of this rubber stamp, yeah, you want an abortion? Sure. Your familial health is really in danger here, or your emotional health, which is what a lot of those late-term abortions were done for. So that Doe versus Bolton case really was the kicker because it defined health so broadly. So let's keep going here. That is really the meat of how this became legal. When you look at kind of the social history going on there, and the fact that 5 people in this country that sat on that bench can make this decision, right? That this, Roe versus Wade, a majority decision is what made abortion legal in the entire country. So just a few minds coming together and saying this, which, looking at laws, it's the state that is supposed to make laws to protect its people. The Supreme Court, all courts are there to simply interpret the law. But here, with Roe versus Wade and these other cases that I've mentioned, there was a real movement to legislate from the bench. They knew they wanted abortion to be legal, and so they worked around that language in Roe versus Wade. And I do recommend, if you have time, to read that case, because it really is mind-boggling how they concluded. So, moving on to later cases, from the mid-70s all the way to really the early 90s, abortion was almost untouchable. You just didn't see a lot of movement at all regulating it. So what's sad to me, it's just so sad to hear testimonials from women who were given abortions during that time, and how they weren't told anything about the risks involved. They weren't told anything about, what could happen to them if something went wrong in that abortion. They weren't even really given the courtesy of being told what was about to happen and what would it feel like after. So these things are informed consent. Anytime you go have any sort of surgery or any minimal thing done in the healthcare field, you have to consent to it. You have to have informed consent. But this particular thing was untouchable. So the informed consent was, just not even a thing with abortion in those early days. Regulations on abortion clinics, it's just so sad to think that veterinary clinics were more regulated than abortion clinics during this time. Dental clinics were highly regulated compared to abortion clinics. So really, when we're talking about this, we really are talking about the safety of people, and just the ability to understand what's about to happen to them, a basic right when you're talking about surgery. That brings us to 1992, Planned Parenthood versus Casey. So this case was thought to potentially overturn Roe versus Wade. It did not. The Supreme Court did reaffirm the right to abortion. However, they did allow several restrictions, if you will, several things that could help in this difficult situation. So they allowed states to have informed consent laws. They allowed states to have parental consent laws. So think about that for a second, that any child could have gone in and had an abortion without parental consent. So they can't get their license yet. They can't vote yet, but they can go get an abortion, which could have terrible effects for the rest of their lives without their parents even knowing. So thank God, Planned Parenthood versus Casey allows states to provide for parental consent. Reporting requirements. This was another big one. That the abortion clinics were now allowed to, the states were now allowed to require abortion clinics to report. Now, this is a big thing happening even today with human trafficking and just anything we can do to help women from being objectified and hurt. What if women were being taken in there, 10, 11, 12 times by their pimps? If you're not reporting, if you're not protecting in that way, how are you ever going to stop that from happening? Or if it's a young woman, a young girl that's being brought in by her uncle to have abortion after abortion because this man is hurting this young girl with incest. How can we do more to help her? That's what these reporting requirements were meant to do, and I think there's more we can do on that front as well. Now, one interesting thing about this case, they also had a husband notification in this case That the court says, no, we're not going to allow husband notification. So even though it's husband, it's not boyfriend, it's just the husband can not even know about an abortion that his wife is getting, because it's not required for him to know that. Like, a state cannot put a husband notification requirement in their state law. So that's very interesting. So overall, we did get a little bit. We gained a little bit in terms of our ability to restrict poor practices in abortion clinics, and restrict times when it's just not good for a young 13-year-old or 12-year-old to get an abortion without her parents even knowing, right? So that, in that sense, that was a victory. But overall, it was not, in that it reaffirmed the right to abortion. I'm going to share with y'all a couple of cases later on, just because it's just, I think it's important in the overall landscape of where abortion is today. So in the 2000s now, a big case, Gonzales versus Carhart, that I would say that that's a very important case in this work. It upheld a federal partial birth abortion ban. So that was a big victory for the pro-life movement, to be able to ban that horrible act of partial birth abortion, which I'm not going to get into here, but if you don't know what that is, there's a lot of information out there. But thank God that is not allowed anymore, to save a mother, except when to save a mother whose life is endangered by a physical disorder, illness, or injury. And there was no health exception. We've had some very interesting cases recently. In fact, our group, Louisiana Right to Life, was able to support legislation on admitting privileges, which this is about the safety of women. And that case, June Medical Services versus Russo, was just heard by the U.S. Supreme Court a couple of weeks ago, and we hope to get an answer on that in June. So lots of just interesting inconsistencies when you look at legislative advocacy when it comes to abortion. So while the pro-choice side claims to be just that, pro-choice, why is it that they don't want a woman to be informed about that choice? So pro-choice lobbyists were against informed consent laws. What about fetal homicide laws, the laws that state that a woman who is pregnant and gets murdered, that's 2 murders, not 1? The pro-choice advocates were against that law. So even though this pregnant woman clearly was choosing to keep her child, because it brought any humanity to the unborn child, the pro-choice lobby was against it. So just kind of pointing out a few of those things in this work. So that is a short lesson on how abortion became legal in America. I encourage all of you to do your own research and to understand just kind of the agenda that was there from the very beginning, related to a lot of eugenicist mentality and just very, very unrestricted mentality when it came to abortion. So I hope you've enjoyed this lesson today, and I hope that you'll listen to more during Virtual Mission Week.